There are a variety of estate planning tools available that accomplish the goal of transferring asset ownership. The commonly utilized tools are wills and trusts. The goals of this presentation are to provide an understanding about what a will and a trust is, provide insight into what should and should not be included in a will, and increase your understanding about when and when not to use trusts. A will is a written document that describes how your property is to be distributed after your death. Generally created by an attorney, the will is a blueprint that explains what will be transferred, how it will be transferred, and sometimes what can be done with the asset. Wills are also used to nominate guardians for minor children and provide distribution instructions for assets after death. Some wills contain trusts within them which provide asset management and distribution for minor children or individuals dependent on you for their care and well-being. These are called testamentary trusts and are only funded and become functional after death and the probate of the will. The will becomes effective following the death of the will's owner. This important characteristic should be remembered when drafting the will. Items that you would like distributed before your death should not be in the will. While not an inclusive list, other items that should not be in the will include do not resuscitate orders or medical powers of attorney. Also, the will does not take precedent over contracts or titles. Assets owned jointly by two or more individuals will be owned by the surviving individuals. Additionally, any assets that list a beneficiary or is titled with a payable on death (POD) or transfer on death (TOD) designation cannot be distributed by the will. Two final items. First, review your will every 3 to 5 years. You may need to make changes if there have been births, marriages, deaths, or divorces in the family, or you change your mind about the provisions you listed. Secondly, to finalize the will, it will go through a probate court process after death. Probate is a process that ensures all of your bills are paid and implements your decisions through a public court-filed process. Moving to trusts. There are many different types of trusts. However, aside from the testamentary trust previously mentioned, the most common trusts are established during lifetime and can be modified and revoked. To utilize a trust, asset ownership is typically transferred into a revocable living trust. Ownership of property, including but not limited to homes, buildings, real estate, bank accounts, stocks, bonds, and life insurance, is transferred from personal ownership into a legal ownership of the trust. The person creating the trust typically retains management authority and names themselves as the trustee. The main reason most people utilize a trust is to avoid the expense and public information access of the probate process. Because the trust is the owner of the assets and the trust can live beyond a person, the trust assets are distributed by a successor trustee or manager after death without requiring probate. Because the assets do not go through probate, the provisions for asset transfer is kept more private and confidential. Avoiding probate costs, which can be significant, is sometimes a reason an individual may use a trust. However, keep in mind that instead of probate cost, trust creation and administration fees will be incurred. As the name implies, revocable living trusts can be changed, modified, or terminated at any time during your life. If a trust is created, each asset must have the title transferred from the individual to the name of the trust. Because a trust can continue to own and manage assets with specific restrictions or instructions after death, a trust can also be a significant tool for transferring assets, usually business assets, to the next generation of owners without requiring the next generation to purchase the assets. This transfer may reduce federal estate taxes and state estate taxes if your state has an estate tax. South Dakota does not. Capital gains taxes or gift taxes may also be reduced. Everyone needs to create an estate plan that accomplishes their asset transfer goals. For most people, a will does that. In estates where families desire privacy, less post-death expense, or wish to transfer business or land assets in an orderly manner, the utilization of trusts may be necessary. Before you proceed, consult an estate planning attorney to determine if one or the other, or a combination of planning tools, are needed to pass on your legacy. For more information on estate planning, visit igrow.org.